The 1964 precedent-making landmark court case Sullivan versus the New York Times defined the parameters for the First Amendment protections applied to newspapers, allowing them a shield from being sued for defamation by a public figure, even when they publish untruthful statements, as long as the print news publication demonstrated they didn't act with actual malice. City of Montgomery, Alabama, Commissioner of Public Affairs L.B. Sullivan, who in the end was deemed to be a public figure in the eyes of the Supreme Court, filed a defamation lawsuit against the New York Times in 1964 for publishing a full-page ad titled "Heed the Rising Voices," which ran March 29, 1960, after 35 students from Alabama State College were denied service at the Montgomery County Courthouse snack bar on February 25, 1960. Sullivan claims the New York Times knowingly did irrefutable harm to his character and good standing when they deliberately ran a disparaging ad painting a portrait of Sullivan as an unsavory elected official. According to Sullivan versus the New York Times, Sullivan alleged he had been libeled by statements in a full-page advertisement that was carried in the New York Times on March 29, 1960. Entitled "Heed the Rising Voices," the advertisement began by stating that, as the whole world knows by now, thousands of Southern Negro students are engaged in widespread, nonviolent demonstrations in positive affirmation of the right to live in human dignity as guaranteed by the U.S. Constitution and the Bill of Rights. It went on to charge that in their efforts to uphold these guarantees, they are being met by an unprecedented wave of terror by those who would deny and negate that document which the whole world looks upon as setting the pattern for modern freedom. Furthermore, the ad alleged to illustrate the wave of terror by describing certain alleged events. The text concluded with an appeal for funds for three purposes: support of the student movement, the struggle for the right to vote, and the legal defense of Dr. Martin Luther King Jr., leader of the movement, against a perjury indictment then pending in Montgomery, Alabama. According to Sullivan versus the New York Times, of the 10 paragraphs of text in the advertisement, the third and the portion of the sixth were the basis of the respondent's claim of libel. They read as follows. Third paragraph. In Montgomery, Alabama, after students sang "My Country 'Tis of Thee" on the state capitol steps, their leaders were expelled from school, and truckloads of police armed with shotguns and tear gas ringed the Alabama State College campus. When the entire student body protested to state authorities by refusing to re-register, their dining hall was padlocked in an attempt to starve them into submission. Sixth paragraph. Again and again, the Southern violators have answered Dr. King's peaceful protest with intimidation and violence. They have bombed his home, almost killing his wife and child. They have assaulted his person. They have arrested him 7 times for speeding, loitering, and other similar offenses, and now they have charged him with perjury, a felony under which they could imprison him for 10 years. Although neither of these statements mentions respondents by name, he contended that the word police in the third paragraph referred to him as the Montgomery commissioner who supervised the police department, so that he was being accused of ringing the campus with police. He further claimed that the paragraph would be read as imputing to the police, and hence to him, the padlocking of the dining hall in order to starve the students into submission. As to the sixth paragraph, he contended that since arrests are ordinarily made by the police, the statement they have arrested Dr. King 7 times would be read as referring to him. He further contended that they who did the arresting would be equated with they who committed the other described acts and with the Southern violators. Thus, he argued, the paragraph would be read as accusing the Montgomery police, and hence him, of answering Dr. King's protest with intimidation and violence, bombing his home, assaulting his person, and charging him with perjury. Respondent and 6 other Montgomery residents testified that they read some or all of the statements as referring to him in a capacity as commissioner. It is unconverted that it is uncontroverted that some of the statements contained in the paragraphs were not accurate descriptions of events which occurred in Montgomery. The act of defamation is a blatant indifference to reporting the truth based on facts. The person making the false statements had serious misgivings as to the truth of the statement, but without any reservations continued to disseminate the following falsehood. The reasoning behind the U.S. Supreme Court's judgment. According to Sullivan versus the New York Times, the general proposition that freedom of expression upon public question is secured by the First Amendment has long been settled by our decisions. The constitutional safeguard, we have said, was fashioned to assure unfettered interchange of ideas for the bringing about of political and social changes desired by the people. Furthermore, false statements are an inevitable part of the free debate that is fundamental to the American system of government and must be protected, Brennan wrote. The only way to win, show that the false statement was made knowingly or with reckless disregard for the truth. The decision freed news organizations to write about the civil rights movement without fearing lawsuits. Gertz versus Welch defines the difference between a public versus a private figure. The reason for the difference is public figures such as celebrities and elected officials have access to communication channels to refute false statements and choose to be in the public eye on a voluntary basis. Private people have no such access, nor are they seeking such attention from the press. News media organizations should, therefore, be responsible for real, not punitive, damage caused by defamatory falsehoods about private persons. Alleged defamatory statements about Gertz and their impact on his reputation. Gertz's reputation was damaged, which could have jeopardized his 15-year standing with his colleagues from the National Lawyers Guild. Furthermore, he was put at risk of losing current and future clients, resulting in potential lost revenue. However, what was egregious is the fact the managing editor of the American Opinion made no attempt to obtain credible sources who could affirm the assertions made about Gertz. There are many lessons learned from the Gertz versus Welch case, which I would consider implementing the following if I was handling the case. First, would weigh the pros and cons of issuing a retraction. Taking everything into consideration, would opt to issue a retraction. Also, would stick to the facts at all costs and remain objective. I would not let my personal feelings influence the story about Gertz. Applying what I learned from the Gertz versus Welch case. Gertz versus Welch has reinforced the importance of attention to detail, and every word does matter, whether spoken or written. Also, the elements of defamation vary dramatically from state to the federal level. For example, the Ohio Supreme Court has declined to recognize the neutral reportage privilege. In closing, the most important lesson learned is always be cognizant of what one says. Never say what one doesn't know, and it's very important to always conduct credible research.